Cragle. I'm General Counsel here at RREAF. Started here as General Counsel in August of 16. I appreciate the opportunity to be in front of you again today. We're going to talk about anatomy of a deal today. I'm a 36-year deal lawyer. I do mergers and acquisitions. Real estate is just a subcategory of work that I do. Every deal, no matter what it is, no matter what its subject matter is, goes through these phases. These will be phases you will work with for the rest of your career, as long as you're in business and business acquisition. Some of you, for example, if you're involved in asset management, may end up down here. It means you have to do the hard work of running the business, figuring out what it's really doing and how we can meet our objectives that we projected up here in the Prelude phase. Just realize that as we go through these, you may find yourself in specific places during your career. Remember all of it, and remember how whatever it is you're doing relates to the other phases that are yet to come. Even though we have all these phases in a deal, inside of every deal, there's always 3 deals going on at the same time. You've got the acquisition of the business or the assets, or in RREAF's case, the property or property portfolio. You've got the acquisition side of that, where we're worried about the legal parts of and the diligence parts of, and we'll talk about that in a bit, of the acquisition itself. But then running parallel with that, all at the same time, you also have the equity capital track. Because we're not gonna, even if we're successful in getting the deal negotiated and through the due diligence and everything looks hunky-dory, peachy keen, and we're gonna get to closing and we hit closing and we don't have equity in place, we're not closing. If we don't have debt in place, we're not closing. So all 3 of these tracks are running at the same time, some of them further out in front, some of them a little bit further behind, but ultimately, at the end of the day, they all have to converge on and hit that one point at the end that we call closing. Each of these tracks has an effect on the other tracks. They're interrelated. If you're working in one particular track, remember there are other tracks running that other people in this room, or what they're doing, is going to be affected by what's happening in your track. So what's the bottom line when you're on a team? Communicate. It's important that we have camaraderie, that we have connection, that we interact with each other. We need to understand how each other think and what we bring to the table, not as a competition analysis, but as a way of making the team better. So be a part of a team. Go listen to people. Go listen to the masters of the craft. And then ask a question. Don't ever hesitate to ask questions. Transaction structuring options. So you can probably tell from the nature of what I'm saying, this notion that a deal has, in effect, a life of its own. It's either a specific property or it's a business and we're going to acquire the business. One way or the other, we have to decide, now we're back to law again, how are we going to acquire it? Are we going to buy the asset? So am I going to go enter into a real estate contract for the purchase and sale of a multifamily property? Or am I going to go to the owner of that entity that property sits inside of and say to them, look, because of, and there may be a series of regulatory issues or other things, we don't want to acquire the asset. We want to do this as an equity purchase. We want to buy all of the equity in your subsidiary that owns this property, and then we don't have to worry about transferring title or anything else, or any of the rights that go along with it. So that's called, that's an equity purchase. So we have kind of 2 basic camps: an asset purchase, where we just literally pick and choose the assets we want, and then we get a bill of sale or a deed, in the case of real estate, and that is the assignment. It's like the title on your car. And then a bill of sale is what your car title is, but it's a car title that's a subcategory of bills of sale, and that is the conveyance of stuff. Okay, that is tangible. And intangibles, by the way. We transfer patents and those sorts of rights, contract rights and the like. We transfer all of those in our asset deals when we're acquiring even apartment complexes. Some of these come with important long-term contracts, and as a result, we need to get an assignment of those things if we're the buyer. So important for us to look into the relationship. We'll talk about diligence in a bit. But again, asset versus equity. Before we move on, let me make one more side comment. As a lawyer, I can tell you I don't really like it being used in this way. It's become industry-wide, not just in the real estate business, but just about everywhere. And that is, we talk about joint ventures. Well, from a lawyer's perspective, a joint venture is a very specialized animal. It's a legal partnership, not a limited liability company, not a limited partnership, not a corporation. It is a partnership between two parties in which they intend or wish to, with a specific objective, only a specific objective, so it's limited to a specific purpose, accomplish whatever it is they're getting together for. So how would a deal like that work? Let's say that somebody has a set of apartment complexes that they'd really like to put into a joint venture with RREAF, and we form a special purpose subsidiary that enters into the joint venture. And what they ask us to do is, because a whole bunch of construction and renovation work and everything else needs to be done, they come to us for financing, and they ask us to put in equity. So the joint venture looks like this. It's a new entity in the center. The owner of the properties conveys the properties down into the new joint venture, and RREAF's subsidiary contributes new equity into the new joint venture. And by doing that, we can negotiate waterfalls and profit sharing and all kinds of things, and management, how management's going to be handled, who's authorized to do what, etc. From a lawyer's perspective, it can only mean a partnership, literally a legal partnership. But in industry, people refer to a joint venture as any arrangement, including limited liability companies or limited partnerships or anything else where two parties are getting involved, and basically they're sort of having that kind of transaction. We're involved in one right now. The term sheet was, I don't know, 7 or 8 pages. The operating agreement for the joint venture, guess how many pages? 109 pages. Okay. I want you to understand what that means. If I ask you to go read a 109-page document, literally put yourself in a room and go read that 109-page document. Keep track of it, figure out how one section relates to the other, what the definitions mean, how they work, those sorts of things. How long do you think it would take you to do that? It would take me, with 36 years of transactional experience and another 10 years before that, it would take me at least a day. I say that to say we start with simple and we get really complex going from here to closing. It's important that we get to complexity because why? The devil's in the detail. Now back to my earlier point, it's important for us not to get stuck down in that detail and forget where we are. So this is really the beginning. What do we mean by prelude? Well, it's really kind of the starting point where a seller is deciding whether they're going to sell and what they're going to sell. It may be an entire business, or in the real estate area, it may be a particular property, like a hotel property, or a multifamily property, or maybe a whole portfolio of them. But here's where the seller's deciding what they want to sell, and the buyers are out in the market looking for whatever it is they want to buy. No way to know that without getting out in the market and figuring it out, right? Nobody's going to come and tell you. Buyers have to know what they want to buy, and sellers have to know what they want to sell in order to do a deal. So depending upon whether you're on the buyer side or the seller side, you'll be looking at a different set of activities to get ready to go to market or to step into a market. So next is the negotiation phase. So once we've identified a target property or target project or target portfolio, we then obviously have to reach out to the seller or the offeree party. Everything we do is based on diligence. And so the very first thing that happens generally is a confidentiality agreement, or what's called a non-disclosure agreement. You'll hear them referred to as NDAs or CAs. I'm the seller, I'm going to share certain information with you. I don't have a binding contract of purchase and sale with you yet, but I'm going to provide some information to you. You need to promise me that you're going to maintain that confidentiality, right? That you're not going to use or disseminate my information, etc. And that'll usually be executed incident to or as a part of a letter of intent, or a term sheet, or a memorandum of understanding. You're going to see all three of those terms during your career, and they all effectively convey the same stuff, right? They are the basic deal terms, the basic economic deal terms, and then usually generic references to things like, the parties agree that the definitive purchase documents will have representations, warranties, and covenants typical for a deal of this sort. Representations, warranties, and covenants are going to be, you remember that 109-page document? Reps, warranties, and covenants are going to be 30 of those pages. They're really, really fundamental to what we do in a deal, reps, warranties, and covenants. But I'm giving you this point that in an LOI, letter of intent, or a term sheet or that sort of thing, you might see a tiny little line, 2 lines on the piece of paper way down in the you'll call it boilerplate that you'll kind of skip over, that says, we agree that reps, warranties, and covenants will be, those that are typical in the industry. Let me tell you, there's a whole lot of them, and I don't know whether all of them are typical or not, but we're now going to negotiate over all of that. And it's important that we end up there because there's so much detail in deals. We can't negotiate all of it up front in the term sheet. And so as a result of that, term sheets, LOIs, and MOUs tend to be non-binding expressions of interest. Okay? And they usually have a non-binding paragraph at the bottom of them because you're signing them, right? Buyer and seller are signing them. Other than the binding part would be the confidentiality. Right? But that's usually in an LOI, MOU type situation like that, that's usually contained in a separate NDA or CA that we've already talked about. Right? You've already got that out of the way. I don't have to have that provision in the term sheet. So you'll see that in some of your term sheets and LOIs, letters of intent that you look at, or expressions of interest. So then from here, from a term sheet, we then, we're negotiating all of the economic terms and side terms, or very important terms that are going to end up in the definitive documents. We're trying to do as much of that as we can, but keep the deal moving. It's important at this point not to get bogged down in the legal side if we can avoid it, right? We want the parties to get together, agree on a non-binding term sheet, and get after it. Because then, as a buyer, what that allows us to do under the NDA is get full access to all their documents, all their history, all their financials, all their returns, those sorts of things. We can really start digging in, because digging in is where the hard part of every acquisition is. But we end up in negotiation. So execution, pre-change and control, that's our next step. We then move from an LOI or a term sheet to what we call a definitive purchase agreement. Now, it may be an asset purchase agreement, it may be an equity purchase agreement, it may be a real property purchase and sale agreement. That can work just fine. You don't have to have a merger agreement or an asset acquisition agreement like we do in M&A practice. If it's real estate, you can just call it a real property contract and away you go. During this next phase, the execution phase, we're going from term sheet to definitive document, and during that phase, we're then going to spend 60 to 120 days in diligence. We're going to negotiate for at least a 60-day window and sometimes a 30-day extension of the diligence period, so the team can dig in and we can really figure it out. For example, in multifamily, the folks down at RREAF Residential will be able to send people on site, physically walk the place, talk to existing management, that sort of thing. But I'm trying to impress on you guys this notion of first impression can have a real effect. We go to a seller and we get through the first steps and we see, there's no diligence box and it's just, poorly put together, poorly thought out. We come back with a different offer because we're dealing with a less sophisticated party, or apparently so. How you say what you say matters, not just what you say. How you say it on paper, the presentation, how you say it when you're in person or on the phone or in a conference call. Even though technology is streaming, is refining and streaming our ability to more quickly process diligence documents in especially bigger deals where it's just voluminous. Thousands and thousands and thousands of pages of documents that have to be read, that historically up to now a human being has read every single word of those documents in the diligence phase. It's essential because one management agreement is not the same as another management agreement. One construction contract is not the same as another construction contract. One license is not the same as another license. So somebody actually that knows what they're doing has to put their eyes on it and literally read it through to figure out whether there are issues there. Even if a human being does that, sits down and does it, they need to do it with perspective. They need to have the width I was talking about earlier, to be able to see that a particular provision is going to not just mean this, but it's going to mean this, this, and this to other parts of the property or the project or its future. I've often said that selling is easy, buying is hard. It's because of diligence. I want to make sure I'm not overpaying for whatever it is I've signed a definitive purchase agreement for, or that I figure out if there are real problems before my deadline date, 60 days out, to be able to cut this thing off, terminate the contract, and get out. During this phase, stakeholders, legal counsel, financial advisors, accountants, consultants, they're all now hired, which means real money is being spent. We're under a contract that's cost us money because of lawyers, and we're now in due diligence that's costing us money with a whole bunch of other people beyond lawyers. So we're going to spend real money here and not be sure that we're going to be able to close. That's a risk factor. Third-party issues are addressed during this phase. So for example, there may be, I've been involved in a number of acquisitions that we didn't do an asset deal because there was one or more super significant contracts or licenses or permits that weren't going to be able to be transferred without getting an agency's consent or a third-party contract consent. Well, master service agreements in the oil and gas industry take a year to get approved. The new vendor is going to supply goods or services to, ExxonMobil, for example, to get them approved so they're able to be in the system and get purchase orders issued to them and even go under contract. If I'm buying the assets and I don't have an arrangement with ExxonMobil or anybody else yet, I'm not going to want to buy the assets. I'm going to want to take the equity and then deal with the rest of it, the fallout. And the fallout is more potential liability. I'm now inheriting the entire history of the organization. I don't know whether they've done stupid things in the last 5 years. I don't know whether there's litigation that's potential out there. Somebody's been hurt on the job and they just haven't sued us yet, that kind of thing. During this phase, we're also working on all the closing documents, right? I mean, we've got this 109-page document, and it's going to call out another 200 pages, so we're close to 250. Yeah. The lawyers are busily working on closing document drafting. Once we get about to the point where what we call hard in the deal, that is, we've gone past the diligence point where we can just terminate. Once we're past that, the lawyers get real involved real fast to get the documents that are going to effect the transaction. Again, back in my deed, bill of sale, those sorts of things. Contract transfers that affect all those things, get all those ready to go for a closing. Due diligence framework. So, most important aspect of this thing is the due diligence. Environmental is very real estate in its orientation, right? You only have environmental liability if you have land. But what if we're doing a deal that involves other stuff, not just a multifamily property? If we're dealing with anything else other than just a straight real estate deal, we're probably going to have other regulatory agencies that we're going to need to answer to, we may be filing with. So we need to look at regulatory compliance. I'll give you an example. We developed the Delta Marriott Hotel in South Lake. We're going to put a contract together and we're going to ask RREAF to sell us the Delta. When we want to get everything that goes along with the Delta, we don't just want the piece of dirt and the building that's standing on it. We want all of its intellectual property rights. We want everything. I don't know if you've been to the Delta, but it has a very nice restaurant and a bar. Guess what that means? It means there's a liquor license. An on-premises liquor license. Okay, I'm buying this hotel, but that's a significant cash flow issue. I need to make sure that I get the permit. You can't transfer a permit, an alcohol beverage permit in the state of Texas. The buyer has to go get their own because there's background checks and all sorts of stuff. So if I want to close, but it takes 6 months to get my own permit, what am I going to do? I'm going to wait. I mean, the seller's not going to want to wait for another 6 months till I get my alcohol and beverage permit. So we enter into side arrangements that allow the existing permit holder to continue to manage and control the alcohol and the alcohol sales under a contract arrangement in the interim until we get our license. And then cybersecurity obviously is really significant. Operational, those of you who are going to be in operations or in asset management, that kind of thing, operational is kind of where you guys will land and live your lives. From a diligence perspective, by the way, those of you who are in operations, you can be a key piece of the diligence team because your knowledge of operations means that you can weigh in on operational issues that we would see in the diligence package. Look at the target's financials. Look at the target's operating statements. Ask some questions. See if there are ratios that just don't seem to be working, right? You guys bring that to the table if you're in the asset management business. So I can look at financial statements and tell you not what they say, because that's not what's important. Anybody can tell you what a financial statement says. The question is, what does it not say? And the only way to know what a financial statement is not saying is to know what accounting methods are, what accounting methods are being used, how particular elements are being entered, what their chart of accounts looks like. And that takes real diligence. Somebody's got to dig down into that. And that's not just a transitional matter, that's an actual diligence matter. When I say risk management, what we're really talking about is transactional risk. That is, I've now entered into a purchase and sale agreement with you, Mr. Seller, or Ms. Seller, and I'm going to do my due diligence, but if we get to a closing and we've found out before we get to the end of the diligence period that your cash flow stream is not what you said it was and those sorts of things, we can either terminate or we're going to adjust the purchase price. Okay, well that would be a risk adjustment in real time, because we think there's problems in your entity with your assets that we're not willing to take on. Another way to do that is to use what we call escrow holdbacks. So let's say we agree on a purchase price and it's $10 million. And we're concerned as the buyer that there may be $1 million worth of hidden liabilities out there that we have some reason to believe could be a problem later. So we negotiate in the purchase and sale agreement that there's going to be an escrow holdback of $1 million. And it's going to sit in an escrow account somewhere, usually with a lawyer, because title companies will only hold escrow accounts about up to 90 days. And those deposits get made, and then they just sit there, subject to the escrow arrangement. And the escrow arrangement is, okay, if certain things happen, then we get that money. If certain other conditions are met, then the seller gets its money. We have indemnification clauses. Indemnity simply means that one party is going to be responsible for another party's obligation. So we'll have indemnification always. In every acquisition agreement, you have indemnification provisions that effectively say, hey, there's a line in the sand at closing. Anything that happened before closing, Mr. Seller, you're responsible for it. Anything that happens after closing, Mr. Buyer, you're responsible for it. So that way the parties have divided responsibility on a calendar basis rather than on a qualitative liability sort of basis. And it can be done either way, but that's a pretty typical way that you draw the line in the sand in an indemnity. There are some things in indemnity provisions that are more far-reaching than that. So risk management, breakup fees, we also see earnouts sometimes. So a seller sells for a particular price, but there's also an agreement with the buyer that if the project produces certain base levels of revenue or returns, that the buyer is entitled to an additional payment a year later or 2 years later. Title insurance obviously usually protects, at least on the real estate side, it protects from some of those risks. If the devil's in the detail, then the devil is the definitions. Don't get drawn into a 109-page contract thinking that you can skip by the 30 pages of definitions up front and then go back into the operative provisions and read them and understand what's going on. Anytime there's a defined term, you need to flip back to it. You need to understand what it says, what it means, what its limits are. So if I want to make sure that something gets covered, but I'd really not like to raise it as an issue, where do you suppose it ends up? In the definitions. So watch carefully. Anytime you read an insurance policy, go to the definitions first. I promise you. The exclusions from coverage and the definitions first before you go back and read the 20 lines of operative policy provisions. The basic idea of insurance isn't hard contractually, right? It's I'm agreeing to pay you if you suffer losses in connection with X. Exit strategies. If you don't know what your exit strategy or exit plan is before you get into the deal, you're probably already dead. Categorically, across every industry and every deal I've ever done, the most successful entrepreneurs that I've represented have always known exits, likely paths to exit that they'd be executing 3 years, 5 years, 7 years hence, 10 years hence, or whenever the opportunity became ripe. Obviously, value add, our holding periods here generally 3 to 7, but I'd say more like 5 to 7 in these days. We have exit sale options. Obviously, we can exit to institutional buyers. We can exit to folks like us. And then performance monitoring, obviously, is critical. We've got to monitor performance as we go along. That really gets into the operational part of the phase. Closing, obviously closing is when we close. We take all those documents we've worked up before, we make sure all the conditions have been met, that the equity money is in, the debt money is ready to go, the debt documents have been executed, the equity documents have been executed. So all stand there ready to go, and we go to the title company and we close. We acquire the assets, we get all the contracts in, and everybody goes down the road. The lender gets its lien against the real estate, the assets, the equity buyers have all their equity, they're holding their equity, et cetera. And the next thing happens is management takes over, right? We shift management, we shift employment. Don't forget that in a deal, people are involved. You're gonna affect the lives of people, whether you're the buyer or the seller. Just be careful about how you manage those relationships and what you're thinking as you develop your way through this. Don't think it's just a mechanical property transaction and it's all gonna be, there's not gonna be any real effect to it, nobody will care. Closing conditions, purchase price, definitive closing documents all get delivered. We finish regulatory and compliance before we finalize closing. If there are compliance issues, we make sure that those problems get fixed, that they get cured, that appropriate reports are filed, and we have acknowledgement of that from the regulatory agencies, that kind of thing. For the seller, this is on the seller side, so that the buyer doesn't take subject to some additional condition that is out there that may or may not happen. And then during the integration phase, this is the other really, really hard part of what you do when you're acquiring businesses. We're now talking with equity owners, employees, vendors, residents. In the case of an apartment complex, for example, residents need to be communicated with, that there's been a change in ownership, those sorts of things. Might sound logistical, but again, because it's a relationship, it's important. It's important that our tenants feel comfortable, that they know that there's somebody real coming in and those sorts of things. And then our operations and systems transition seems like it's the part of the business that you guys would be most likely to focus on. That's the obvious thing. Operationally, I need to make sure that my people are right, that if I've got to have new maintenance people, that I bring them in, that maintenance facilities are available, they're ready, they're in good shape, those sorts of things. In other words, all the operational matters all need to be handled. We're going to do systems integration that is that's truly incredibly important. Generally, an asset will not be operated under the same accounting system that we may be operating under. And almost with certainty, it will not be operating with the same chart of accounts, the same accounting chart of accounts that we operate from, so that we have the management detail we need to be able to manage certain subcategories of information. So I can tell you that one of the most important things we do is look at charts of accounts on the accounting side and figure out how this information from their system is going to be directed into our system or referable from our system, so we have apples to compare. Because every lender and every other party we deal with from now on after closing is going to want a comparative analysis of how the property performed. And that means we're going to be stuck with the data that the seller had and only be able to use whatever it is they gave us. So if they didn't parse out the right kind of, those of you that are around accounting, management accounting information, if they didn't get that parsed out by virtue of a much more complicated or complex chart of accounts that will allow asset management to see certain categories that otherwise may be lumped into 3 other things, we won't be able to manage. We won't be able to see it. We won't be able to compare to it. We can manage, but only from the line in the sand going forward, right? We'll be building our own database, and we need to be able to relate back to them. So systems, including accounting data, is truly critical in these settings. And then cultural alignment. Cultures are different. The way management speaks, the words it uses, its mode of communication, those sorts of things. Really hard to transition these people into the RREAF way. It takes time, it takes training, it takes, and we're not just talking about dealing with line level employees, we're talking about dealing with the manager, people who have their own way of thinking, have been thinking this way for 30 years, long before we came along and bought the property. Now we're talking about relationship. We're talking about teams working together. We're talking about getting culture right. Cultural is really hard. It's a hard integration. So the rest of it's fairly mechanical, software and accounting, those kinds of things. And then we're off into steady state operations. which is, sort of, okay, you now own it, run baby run. And you're not just monitoring performance, now you're trying to optimize. And hopefully the acquisition was strategic in that you were thinking there were synergies or other things that would make a difference in the net, right? In the NOI of the property, because that's kind of really what it's all about at the end of the day. Because the NOI then drives the sale price later and all those sorts of things. And what we're doing, preparing for a future exit, which we've already thought about from the very beginning, but now we're working on getting this thing ready for an exit. Even if it's day one, you're beginning to get this asset together so it's ready for an exit. Real RREAF example. In 2022, we acquired 10 multifamily properties in 7 different states, and we acquired them all from the same seller. It was a portfolio acquisition, but every one of the properties had its own debt. They were all Freddie Mac financed. Freddie Mac is one of the guarantee organizations that functionally the federal government guarantees or backs the indebtedness. So a local lender or a regional lender will be the originating lender, but they'll have a guarantee from Fannie Mae or from Freddie Mac on the guarantee. So we acquired these 10 properties. They all had separate Freddie Mac loans on them, but the lender required that pairs of 2, 5 pairs of 2 properties, the lender decided which pairs went together, had to be cross-defaulted. Cross-default means I've got 2 loans or 2 contracts, and if it's cross-defaulted with the party upstream, it means that if I fail under one of these contracts, even if the other contract is doing great, that goes into default at the same time. It gives a lender more negotiating leverage, more leverage over how it deals with problem properties, etc. Not unusual to see a lender in that situation put a really good performing property with a questionable property, because they want to protect against the questionable one causing a problem in the portfolio. Equity capital in that particular deal included both retail equity that we raised in a private offering, in a Regulation D private offering, which we do a lot of here, from the market, what we call the retail market, and then it also was such a large portfolio that it included preferred equity from an institutional investor. Remember the 3 tracks: deal tracks running, equity tracks running. Well, the equity track wasn't just running by itself. There were 2 equity tracks running. There was a preferred equity track running that was negotiated in the documents, and then the offering was running for the retail equity. Lender requirements have to be understood. You have to know what they're doing and how they affect the portfolio. We've got mixed equity structures, as I've suggested. Retail and institutional equity can sometimes get together, and we've had that happen in a number of cases here, where the projects are really large. Deals involve process, as you can tell, right? Each of these phases is a process. They're necessary to every execution, even though they may differ from one industry to another, or one type of transaction to another. Our RREAF deals vary, sometimes significantly. So we have to keep our eyes on each one of these issues as we go, even if the last 10 deals we've done don't raise this issue. Deal variation demands mastery of the acquisition process and problem solving, which together foster our agility and our ability to provide opportunity. Thank you so much for your attention today. If there's anything I can ever do, if you ever have any questions, career questions, anything like that at all, you can find a card up here. It's got my cell phone number on it. Text me, please do not call me. I'm here for you guys. Look forward to working with you.